So I'm assuming all of you know what federalism means, right? Mm-hmm. Right, that we're a country that is made up of states with a constitution in which we've delegated certain powers to a national government, and that the difference between the powers of the national government and the state government is what's referred to when we talk about federalism. There is a component of that called judicial federalism. And so, judicial federalism is a recognition that in our state, in all of the states actually, each of the states has their own constitution. In addition...
Okay, Matt, you're up. There you go.
Thank you.
You're welcome.
So let me pull up.
Let me do this.
So it's a recognition that that our Constitution means something. Now, throughout your whole and thinking back to your civics classes, have you ever learned anything about the Ohio Constitution?
No.
But you probably learned all about the United States Constitution.
Yeah, right.
What do you think plays more of an impact in our daily lives between the two?
Ohio.
The state, right? Because that's exactly what our founders actually thought. You know, we talk a lot about the Bill of Rights. Do you know why the framers in the original Federal Convention of 1787, why they didn't include a Bill of Rights? They thought, why do we need it? We have state constitutions, most of the state, not all, but most of the state constitutions in 1787, all of the states had a Bill of Rights. They thought, the states will protect us. We don't need to have an additional, additional protections against the federal government. The states will make sure that the federal government doesn't get out of control. We will have recourse to our state governments when the federal government gets out of control. That's why we don't need a separate Bill of Rights or a federal judiciary to keep the federal government in line. We have the state governments.
And they elected the senators at one time.
They did. So, anyone know what common law means? By a show of hands? I've got a couple.
Like common law marriage.
Yeah, right. Marriage.
So this presentation is called "The Common Law Restored: How Independently Reviewing the Ohio Constitution Can Best Protect Our Rights." This is based off of a forthcoming law review article that is going to be published in Capital University's Law Review that I have authored. And so the reason I started doing this research is due to a case out of our state Supreme Court called State Ex Rel Cincinnati Enquirer versus Bloom, where the Ohio Supreme Court, this is a line they've said several times before, but I'm hoping this time they mean it, that the Ohio Constitution is a document of independent force. And in this case involved, Nancy didn't go through my whole background, but I currently serve in our county's juvenile court system as a mediator and a magistrate. And this case came out of the Hamilton County Juvenile Court. It involved a juvenile who was involved in a homicide. And unfortunately, the juvenile ended up dying young, dying before his case was even concluded. And because the homicide was big news down there, think of think of what happened today, right? Like, it was in Cincinnati. There were, it was a big deal. It was kind of a major shock at the time that this kind of thing happened. And the case was never resolved. And the Cincinnati Enquirer wanted to report on the details of what happened. But under our state law, juvenile cases, once they are concluded, and in this case, the case was concluded by the death of the juvenile before he was brought to justice, were automatically sealed. And the Cincinnati Enquirer wanted the court records released so they could learn what actually happened, what the police actually investigated, everything that happened with this case. So they sued, and our courts up to this point, in regards to access to court records, did not follow our state constitution. They followed federal jurisprudence, meaning what federal courts have said, when across the country litigants have filed to get court records and claimed a right under the federal constitution for court records. How have the federal courts recognized a federal constitutional right to court records? Believe it or not, they found that right in the First Amendment. Now, I don't know if any of you have the First Amendment memorized, but do you guys know where anything in the First Amendment has to do with access to courts? No, there's nothing there. And under that federal jurisprudence, courts across the country have said you don't have the right to juvenile records. And so the Cincinnati Enquirer pointed out, there's this, where's the pointer aspect of this? Is it this?
It's right on the little red.
I'm moving forward now. Okay, here.
Yeah.
There's this provision here of our state constitution. All courts shall be open. And the Cincinnati Enquirer believed that meant not only could you go into all courts, that it was publicly open for people to walk in and out of, but it meant that the records of the court should be open and available. And the Ohio Supreme Court agreed. And they basically said that we need to interpret the Ohio State Constitution on its own, as its own document, not as just a corollary to the federal Constitution, or what happens in effect nowadays is whatever federal courts say the U.S. Constitution means. So that the federal guarantees of the Ohio Bill of Rights have undiminished vitality, and Ohio courts are not bound to walk lockstep. In other words, just whatever the federal courts say the U.S. Constitution means, that's what we're going to say the Ohio Constitution means. That's what lockstepping means. And that when a judge says that, they are violating their oath to support the Ohio Constitution. When I was sworn in as a magistrate, I swore an oath to uphold both the United States Constitution and the Constitution of the state of Ohio. If I'm just following the United States Constitution, I would be ignoring my oath to the Ohio Constitution. And so what the courts announced in this case, which they hadn't done before, they have independently reviewed the Ohio Constitution in the past in a very small number of cases, but for the first time, and this is a big deal, they have said that now they will revisit past precedent. So they are willing to overturn old cases where the courts have said the Ohio Constitution means whatever the U.S. Constitution says. So as a lawyer, this excites me. This is something that, I'm a little weird in that way. I get giddy about the fact of creating new law, creating new precedent. This is something that, as conservatives living under a system that has been dominated by liberal thoughts on what the law is, what the Constitution means, this is a golden opportunity. So I wanted to look into this. And so I started with the very same constitutional provision that was at the basis of this particular opinion. So the Ohio Supreme Court only talked about this: all courts shall be open. But this provision of the Ohio Constitution, Article 1, Section 16, has a lot more to it. It goes on to say, every person for an injury done him in his land, goods, person, or reputation shall have remedy by due course of law, and shall have justice administered without denial or delay. Suits may be brought against the state in such courts and in such manner as may be provided by law. So I started looking into this, and the first question I asked is this one of those provisions that the Ohio courts have basically been in lockstep with the federal Constitution, and no surprise, it has been. That there is a case from the late 19th century, Adler versus Whitlock. It was a case about where a bunch of a coalition of barkeeps essentially challenged the state tax on liquor. And one of the challenges of it was based on this, remedy by due course of law, that they basically said that the state was illegitimately taking their goods, right, their money, in the form of illegitimate taxation, and they didn't have a remedy under due course of law because the tax was so complicated. It was completely couldn't understand it. It was basically a due process violation. And the court in that case said, well, due course of law, that sounds like due process under the 14th Amendment of the Constitution, and we've got federal courts that say you can't challenge taxes under the due process clause, so you can't do that here. And ever since, Ohio courts, whenever a litigant has brought forth this provision here, the rest of this first sentence, the second clause, after all courts shall be open, they basically have reviewed it under the 14th Amendment due process jurisprudence of the federal courts. So Justice DeWine, who is the lead author of the Bloom opinion, also has a forthcoming law review article out in which he explains how he would like he and his colleagues on the court to review these types of cases. And he says, first we look at the text, then we look at the history and tradition. So looking at the text here, you'll see that the text of Article 1, Section 16 is very different than the 14th Amendment to the Constitution, which protects all of us in regards to having our life and liberty protected under the from due you can only have it taken under due process. This is talking about something different. This isn't talking just about having our life, liberty, or property taken by the government without due process of law. This is talking about injuries we have. And as our last presentation showed, our injuries don't always come from the government. That we have a right to our land, our goods, our person, our reputation, and if there is an injury to them, we shall have a remedy. And that remedy shall be by the due course of law, and separately, that justice shall be administered without denial or delay. So that just the textual clues give off that this maybe should be treated a little bit differently than the 14th Amendment. So let's look at the history and traditions that arise from this. And they go back centuries. Anyone know who these guys are? You guys ever heard of them?
They took over Rome, basically.
They did. But before they got to Rome, after the Romans retreated from the Britannic Islands, or at least Britain itself, these are the guys who came into England, the Angles, Saxons, and Utes. And why I bring them up is because both at the time of our nation's founding and even at the time our Constitution was passed. Anyone know when our state Constitution was passed? Anyone know? 1851. Our state has had two constitutions, an original one in 1802, a second one in 1851. Even in 1851, in the debates in that convention, our framers of our state constitution referenced these guys. And of course, there's been a lot of historical revisionism over the years to challenge the conventional belief that all of our traditions, our heritage, our legal heritage, comes from these guys. A lot of modern day historians say that's a bunch of, made up stuff. But our founders believed it. Whether or not it's true or not, the fact that our founders believe it makes it relevant for purposes of legal interpretation. That our traditions came from these guys. Now, the earliest actual written recording that we have that we can tie directly to our state constitution, Article 1, Section 16, is the Magna Carta. So to understand why the Magna Carta was written, what those words mean, and the relevance it then has to us today, we do need to have a little bit of an understanding of what was happening in early 13th century England that caused it to be written. Anyone know the story of Robin Hood?
Mm-hmm.
Yeah, that's a true story.
It is well, Robin Hood itself isn't true, but it's based on some real things that happened. Was it all about robbing from the rich to give to the poor?
Well, it's King John's despicable acts.
It was more about King John's despicable acts. It was about robbing from the government to give to the poor. the bad guys in the story of Robin Hood are the government. It's this guy. It's King John. I know many of the people here might be against the concept of forever wars. So the original forever wars for our history and tradition were the wars between England and France. So I don't know how much you guys may recall your English history. Everyone familiar with William the Conqueror?
Mm-hmm.
Okay, Duke of Normandy, claimed the kingship of England, conquers England from Normandy and France. Ever since that time, the royal household in England had extensive land holdings in France. And even though they were king in England, as dukes of actually a majority of the land in France, they held that in fealty to the French king, which led to a lot of conflict over roughly 200, almost 400 years, depending on what dates you use. And at this point in time, King John had just lost nearly all of the English possessions in France to Philip II of France. And he did not like that because it was his patrimony. He was related to William the Conqueror, who was the Duke of Normandy, and he lost Normandy to the French. And he wanted to get it back. But he didn't have the money to keep fighting France. So what was he doing? He was taking that money. He was throwing people in prison for not giving him the money he needed. He was sending out his thugs to threaten nobles for money and having them beat them up if they weren't giving them money. He was exiling people out of England so he could take their land and then get all the taxation from that land. That in that feudal system, everyone was basically a tenant of the local lord or duke, and he could get those tenancies from them by just seizing them and exiling the local lords. That is what led to a rebellion. That is what led to the Magna Carta. And one of the reasons we know that Magna Carta is tied to those Angles, Saxons, and Utes is because the people at the time said it was. The main architect of the Magna Carta was this guy here, the Archbishop of Canterbury, Stephen Langton. He said, hey, I don't like war. I don't want you guys rebelling against the king, but I understand that the king hasn't been doing the right thing. How do we keep him on the right path? How do you guys like the idea of holding him to the ancient traditions of our Anglo-Saxon forebears? And the Baron said, we had freedom under that system. That's what we want to go back to. And that's what the Magna Carta meant to them. And so that was signed in 1215. King John immediately repudiated it, actually complained to the Pope. The Pope said it was no good. But then King John died. And he had a minor, Henry III, who was not old enough to govern the kingdom on his own. And so this is what gave the barons the opportunity to actually enforce Magna Carta. As they said to the minor, Henry III, we'll recognize you as king if you uphold Magna Carta. And so Magna Carta in its final form wasn't finalized until 1225, and in its final form, the language that we can now connect to our state constitution is here. And it says, no free man shall be in future arrested or imprisoned or disseized. I mean, that was the word at the time to take property away from someone. Of his freehold, liberties, or customs, outlawed or exiled or victimized in any other way. And this is how we know what King John was doing that was illegal, because they're the things that they're saying now Henry III can't do anymore. Neither will we attack him or send anyone to attack him, except by the lawful judgment of his peers or by the law of the land. And then the second sentence is what correlates to that justice being that neither delayed or denied. To no one will we sell, to no one will we refuse or delay right or justice. This was another thing King John was doing to earn money. So this is another thing I need to talk about really quickly to understand what the common law is. So at the time in England, every lord was a court unto himself. So whether or not you were a duke, you were an earl, if you were an abbot, if you were a bishop, you held your own court. You had the right to administer cases and all of your property. And everyone on your property was basically a tenant of you. And there are different types of law you would administer in your court. There was feudal law, there was ecclesiastical law that would be administered by the abbots or the bishops in their territories. They still had Roman law. Those laws were kept on. Whether or not they, in what cases they used it is something up to historical debate, but they still had an understanding of Roman law that they would sometimes apply. There were the Germanic laws from the original Angles and Saxons. There were territories that were conquered by the Danes over a period of time in the early Middle Ages, so there was some Danish law that was still being applied at the time. But they had all different laws, and one of the ways that the Norman kings enforced their authority was through a writ system, in which case the king was claiming universal authority to administer the law over and kind of on top of each of those local courts. And how he did it was people would basically make a pleading to the king. Is everyone familiar with pleadings in the legal context? That's like the initial complaint that you would file in a court. And this is how our concept of complaints derives from this system, where someone would make a pleading to the king, and then the king would issue a writ to a local authority, typically the sheriff, and say, this is what you need to do to remedy this complaint. And that is how a common law, a law that was common throughout England, developed. But what John was doing is he was selling these writs. It was a way for him to get money to have his war with France. He was selling them to the highest bidder. And then if there was someone he didn't like, he would deny the writ. He would deny that person justice. Or he would sit on it and just not act on it. He would delay justice. So that is the connection to our state constitution, is that those violations that happened way back in the 13th century. So I want to tell you a little, so we're going to fast forward a few centuries, because the next time we really see this brought up, and this is Edward Coke. At the time of our nation's founding, he was known as the preeminent scholar of the common law. And he had his own battle with the king. In this case, it was King James I of England. That would make him 6th of Scotland. But he was a jurist. He sat on a court that administered the common law in the early 17th century. And what he believed was that the common law took precedence over the king's own will. So that if the king wanted to do something but it violated common law, he would say, king, you can't do that. And as you can imagine, the king didn't like that. And so the king was trying to be politically savvy. Instead of just going after him or arresting him or kicking him out of his position as a judge, he promoted him. He promoted him from a common law court to a court in equity, which is a different type of court in which there are different remedies, different procedures. And if you guys are familiar with all there's been a lot of noise about equity recently because we had a good United States Supreme Court case that limited the equitable powers of the federal courts if they follow the Supreme Court, but that basically said there's no such thing as one of these universal injunctions. That comes from these courts of equity. But the king thought that by taking him out of the common law courts, he wouldn't be able to enforce that common law over his will, but he still caused trouble for the king, and so the king did end up kicking him out, firing him from his job as a judge. But that gave him the opportunity to write a treatise of the common law, which is what all of our founders who were attorneys, and even some who weren't attorneys, that is what they studied at the time of our nation's founding, was Coke's interpretation of the common law. And I'm not going to go through all of this, but it basically summarizes what the rights people had under the Magna Carta. This is a little bit easier to read, so I'm gonna skip to Blackstone. William Blackstone was a contemporary of our founders, but was a jurist in England at the time. And what he's the guy now that our federal courts will more likely cite Blackstone rather than Coke when talking about what the common law means. And he separated rights into two different categories. There are absolute rights that exist in the state of nature, and those are your personal security, personal liberty, private property. So personal security includes the right to your life, your health, hearkening back to our last presentation, your reputation. Personal liberty is about freedom of movement, or another way of saying it is freedom from restraint. And then the use of private property. There's a free use, enjoyment, and disposal of your acquisitions without interference or diminution except by law. Again, hearkening back to our last presentation, your house is your property to use and enjoy as you see fit in a state of nature. And liberals seem to have a difficulty separating these two concepts, as was apparent by Senator Tim Kaine's remarks. This is what God gives us, right? But when we're in a community, how do we keep and protect these God-given rights? That's where this concept of subordinate rights come from. This is where we agree with each other how to protect these. And that's where we have the right to a remedy, the right to a court of justice for the redress of injuries. But it's also, another subordinate right is the right to a jury trial, the right to only have taxation with representation. Those are subordinate rights, but they don't take away our absolute rights. They help enforce them. These come from God. These can come from government. And Tim Kaine needs to relearn that lesson, but I digress. So this is something that was important to our founders. It's one of the reasons that we separated from Great Britain. One of the reasons I think the court should be quoting Coke more than Blackstone is because the reason that we separated from the mother country isn't because of the king and we were rebelling against monarchy. We were actually rebelling against a majority rule of parliament, a parliament that did not include direct representation from us as colonies, but thought that it was above the law. One of the things Blackstone was a big proponent of was this concept of parliamentary supremacy, that if Parliament said this was law, that law could countermand what the common law was. Koch, on the other hand, separated categories of law into customs, statutory law, the laws passed by Parliament, and common law. And he had them in that order: customs, statutory law, common law at the top, and common law superseded statutory law. Parliament didn't think that way. Parliament thought that if they passed it, they could violate the common law rights of the colonies. And the colonies fought against that. You can't violate our common law rights. And what are some of the things Parliament did at the time that violated the common law? We don't have to guess, because they put it in the Declaration of Independence. One of the things that they gave as one of their causes for independence was the fact that Parliament abolished the common law in Canada. I don't know how many of you know this. If we hadn't rebelled, what original colony would we have been a part of in 1775? Anyone know?
Okay.
Canada! The king extended Canada's boundaries into the Northwest Territory and then abolished the common law. So all of these original, a lot of our founders, George Washington included, that's how the French and Indian War started. You guys all know that? It was because George Washington was sent by the governor of Virginia to claim Ohio for Britain rather than France. And George Washington had a lot of property, invested in a lot of properties along the Ohio River to include the southern portion of our state. He didn't want the common law to be abolished here. That was this heritage. That's why how he guaranteed his rights against tyranny, and that's how the other framers thought as well. And then we all know what the English did to the colony of Massachusetts. That after the Boston Tea Party, they abolished the Massachusetts government, treated it as being in a state of rebellion. So they were obviously taking away the common law rights of all the people of Massachusetts based on what a few guys did in the Tea Party. So that was one of the reasons we rebelled and declared our independence. So the next place we see the same language as in our current Constitution is in the Northwest Ordinance of 1787. So as our Constitution was being debated, the members of the Confederation Congress put this together. And what I want you to look at, I don't know if you ever were actually taught this, if you were ever taught in school about the Northwest Ordinance. I found this very interesting. The opening of the ordinance is that these articles shall be considered as articles of compact between the original states and the people and states in the Northwest Territory, meaning us, we're Ohioans, forever remain unalterable. Forever. That means now and later until forever. Unless by common consent, which means not just our consent within the territory, but also between the national government or the peoples of our sister states, all of them. Oop, I don't know what just happened.
There it is.
There it is, it's back on.
Oh, I don't know why it went all the way to the end there.
You might have flipped it by accident.
Anyone? We could probably just start the slideshow again. Okay, so for purposes, again, a lot of our rights are listed in here, but for purposes of Article 1, Section 16, I just want to focus on this. And of judicial proceedings according to the course of the common law. So when our original delegates to the Confederation Congress set up our system of government, they intended the common law to apply here in this territory forever, unless we as a people and the federal government agreed otherwise.
Ran out of battery.
Yeah, that's okay. I'm loud. Wait.
Yeah, I
No,
can hear you.
it's done. You guys can hear me anyways. So in 1802, we passed our first constitution. That language in Article 1, Section 16 was basically the same in 1802. It was just in a different provision of the Constitution. It was moved up in the 1851 Constitution. But that language wasn't something that our original state framers just came up with. It was found in most of the other state constitutions. We actually took it from Tennessee. Tennessee took it from Kentucky. Kentucky took it from Pennsylvania. Pennsylvania took it from Massachusetts. And a few of the other states had very similar language. So how was that actually enforced originally before the 1851 convention? There were a few ways. So the first case that I found goes back to Massachusetts, and it was a case where they were having problems with mill owners whose mills were causing flooding. Because to build a mill, you end up having to dam a river so that the force of that river can be used to generate energy through the mill. Right? But what happens when there's, bad rainfall and there's that dam there, land was getting flooded, and there was, for whatever reason in Massachusetts, I don't know the topography or geography there very well, but for whatever reason there was a proliferation of suits of people suing mill owners for damages to their property. The Massachusetts legislature said, this is getting out of hand. We need to have a better system of administering the damages to these suits. So rather than people suing under the common law, we're going to set up this alternate system for people to get damages for when their land is flooded by mill owners. And one of the mill owners didn't really like it, and because, as you can imagine, whenever a legislature tries to come up with its own remedy, have you guys ever looked at the Ohio Revised Code? It's not good reading. It didn't make sense. And so one of the mill owners sued, or it was actually some guy who had his land flooded, sued a mill owner and wanted damages at common law. Common law is easy. We know what it means. We know how to assess damages. We have a jury to do that. I don't want to go through this process of whatever the legislature set up. It's confusing. And so this case went all the way up to the Supreme Judicial Court of Massachusetts, their version of the Supreme Court, under the Massachusetts version of the right to remedy provision that's found in our Constitution. And they basically said the legislature can change common law, can take away a common law remedy as long as they provide another remedy, even if that remedy is confusing and not very good. Because you can end up voting other people in to change that law and make it better. So that's called the quid pro quo approach to this constitutional provision. Some other cases that I found were in regards to judicial delays. Another common thing that we still see today is people not wanting to be liable for some of the commitments they make. And especially when there's a economic situation, like a lot of cases I found came out of the panic of 1837. We call these economic downturns depressions now. Back in the 19th century, they were panics. A lot of people didn't have money to pay on their mortgages anymore. Banks were coming in and seizing property. People were complaining to their legislatures. It's not fair. I didn't pay my mortgage and the bank took my home. You can't kick me out of my home. You need legislatures. You need to do something for me. A lot of legislatures then passed they suspended judgments relating to foreclosure. So if a bank came to try and foreclose on your property, they were granted the right to foreclose on your property. They wouldn't be able to actually take another person's home for a period of time. We had a lot of cases from this point basically overturning those statutes because it was justice delayed. If you are suspending the execution of a legal judgment, you are delaying justice. It's strictly against this language in all these state constitutions that says justice shall not be delayed. and it can't be denied. I found a couple cases that illustrated what how this was. An interesting one that I found was in regards to a case that required it for a particular case. Before you could actually file a complaint, you had to come into court, you had to testify in open court as to what your complaint was, rather than just write it down and file it. And then for that testimony to be administered in evidence later at the actual trial for that, you had to have 3 witnesses come in to support that testimony. The court in that case said, that's basically justice denied. You are putting in too many obstacles for someone to have his day in court. There's no reason to come into court and state your complaint orally on the record when you can write it down and if needed have someone notarize your complaint. It's just, a notary in an affidavit is the same thing as testifying in open court. Why have people go through that hassle and then have 3 witnesses to support it? That's 3 too many. You could have 1 person testify to something and be credible. So that was effectively justice denied. So those were the examples that when the framers of our state constitution had as to what that clause meant. And that is how our state should be looking at this clause now, with those examples in mind. So what does an independent Article 1, Section 16 look like? Does it mean the Ohio legislature can abrogate the common law, take the common law away? I think when you look at the history, the full history, going back to Magna Carta, which our English forebears said the king can't do this because it violates the common law. Coke again, the king can't do this because it violates the common law. Our nation's founders, the king and parliament can't do this because it violates common law. That is what this provision was about, was to keep our legislature, our executive branch officials, whether or not it's a governor or a board of county commissioners or a mayor, whoever the case might be, they cannot violate the common law. It's a law that is above statutory law. But at the very least, it means if you're going to take a right away, you have to replace it with something. If we have a right to our bodily integrity and our health, they can't take that away by mandating that we use a particular type of device that's attached to our homes. They have to give us a way to remedy that. It can't just be you have no choice. So, at the very least, it means that they cannot limit a remedy without offering a replacement. I think it also means that if there are conditions to filing a lawsuit, whether or not those are by statute or whether or not they're by court rules. So, does anyone know that we had an amendment to our Constitution back in the 1960s that allowed the Supreme Court to make all the rules for the Ohio court system? So our Ohio court rules aren't set by our state legislature, they're set by our state Supreme Court. And then each court can then develop its own local rules. But the Supreme Court could be violating the Constitution it's sworn to protect if it creates rules that delay or deny justice. So this is how we take our rights back. The federal government isn't there to protect us in all circumstances. The founders of our state and the framers of our current state constitution did not have that kind of faith in government. They expected us to enforce our own rights in a legal system that allows us access to the courts, to sue when necessary, and that constitutionally we have a right to remedy in our court system when we're injured. And so this is how we take our rights back. It's not by necessarily going to the federal Constitution and the Due Process Clause, but going to our own Constitution. And so I'm hoping that by getting the word out here and more people are aware of it, they know what their rights are, and who knows, we might see some cases coming forth that vindicate this thesis. And I'll take questions. We only got a couple minutes left. Go ahead.
Just as a
Albert.
question, they were talking about that notice to the utilities.
Mhm.
Is that a legal notice under the common law?
Well, without having looked at it, I can't say whether or not it's legal. But what I can say under this is that if you have a right to remedy to a damage in your person, and these smart meters are causing you ill, you should have a right to remedy under our state constitution for any damages that come from that illness, from the person or company that caused that illness. And if that company is a utility company, or if it's your own city, I live in Painesville, so the city manages our utilities. There should be an action on that.
Well,
And if state law prohibits you from getting a remedy, that is something that should be challenged under this constitutional provision.
but you have a problem with that because proving it.
Right. You assume you
Can I address that?
Go ahead.
He's, that notice of liability is a legal binding contract, and it is
Yeah,
upholdable in court.
You still wind up in court
You,
having to prove it.
well, what they have to do is they have to prove their innocence. Right, when you start hitting them with these notices of liability, then they have to prove that what they're doing isn't causing harm. But there's a mountain of data that proves that it is. From what we know so far, we haven't had a notice of liability go to court. We've had companies threaten that they were gonna go to court with it if they didn't drop the notice of liability. But when people stood on them about it, the companies backed off. They backed off when it comes to notice of liability. So it's a legal binding contract between you and whoever you served it with. And they are required by law to prepare a defense to that. You can't just ignore it.
Go ahead, Brian.
Yeah, Matt, on the property tax issue, one thing that we found out is with the sexennial revaluation, the counties, Lake County paid $1.8 million for a third-party appraiser to appraise all the properties. When we addressed the third-party company, we said, we'd like to see your calculations. They're saying, no, that's all proprietary information. So what we have said to the officials in Lake County, so let me understand this. You paid $1.8 million to a third party that controls our destiny, but is not accountable to us. That seems like what we were fighting with the Tea Party back in Boston back in the day.
Yep. Yep.
Am I missing something on that?
No, but what I'll say, based on that Adler case, you would have trouble suing to claim that the taxation, right? The taxation is unconstitutional. Where you may find an opening under this provision of the Constitution to get at some of these third-party evaluators is and we're going to see this happen now, because we already see that the market is flipped. That now we have it's more of a seller's or a buyer's market than a seller's market. The rate at which a lot of these homes are being evaluated is based on the hot market that we had, around the time of the pandemic. And people are not going to be able to sell their homes at the rate that these evaluators value the property at. And then people are going to be, kind of double SOL, because first they're paying more in taxes based on this outrageously high valuation, and then they're going to have to sell their property for less because no one's willing to purchase their house at that high valuation. That might be an injury under our Constitution.
Yeah.
And that may be where you can get at some of these valuators. You valued my property at a higher rate. I now suffered an injury in regards to my inability to sell it at that rate, and hey, maybe you should pay the difference.
Matt, what do you think the Ohio Ohio Constitution it's been changed 174 times.
Yep.
I always thought of the Constitution as sort of a bedrock, a rock solid, but when they're using it like the Ohio Revised Code, that seems to me like it's defeating what the purpose of the
Exactly.
Constitution was.
It essentially devalues our Constitution. One of the things, again, people don't know, when the Magna Carta was first passed, there was a requirement that in every single city and village, every single church, actually, twice a year they had to read the Magna Carta. I think it should be similarly, twice a year, there should be a national reading of our federal Constitution and our state Constitution. You know how long it would take to read our state Constitution when it starts reading like a statute book? Maybe by requiring it to be read that often, people would have a little bit more respect for it. And treat it more like we treat the federal Constitution, as a higher form of law that doesn't need to get into these nitty-gritty details like a statute, but just that says that talks about our rights. Simply talks about what our rights are and what the government can and can't do. That's all we need in the Constitution.
Isn't there a Constitution Day for schools to do?
It's coming up.
The September 17th is Constitution Day for the federal Constitution. I'm not aware of a Constitution Day for the Ohio Constitution. Go ahead.
Could this somehow be utilized to get rid of these chemtrails?
I think power movement is on that too.
Is it?
Yeah, they have to do another piece of water and.
Yeah, and again, you guys, you have an absolute, you have a, you know, talking about those absolute rights. You have an absolute right to your health, to the enjoyment of your property. And one of the things about the common law was that it worked out the balance of those rights. Because just like I used the example of that early case from Massachusetts, the right of that mill owner to build a mill, to operate a mill, to get his income from that mill, he had a right to all those things, just as much as the next door neighbor had a right to enjoy his property without it being flooded. But life happens, and those rights combined against each other. And the common law was a system that is literally over 1,000 years old to work out how those rights are meant to be, you know, how they're meant to be adjudicated when they conflict.
About the meters.
And they're a trusted system, so that if chemtrails are an issue, if these EMFs are an issue, again, you know, we don't necessarily want to be depriving people who are, you know, developing those things for a good economic purpose, right? I mean, those chemtrails don't come from nowhere. They come because someone was using them for, you know, for a commercial purpose, to generate income, which will end up having good downstream effects on the economy and our community, but also, obviously, some bad effects.
So this could be used for COVID problems too, couldn't it?
Yes, that's what I love about our Constitution and the common law is it does have an answer for everything. We get into the system that the only things that are good are the things that we think of right now, and we can forget about what happened in the past. I like the system of tried and true. That if something has worked for 1,000 years, it can work for another 1,000 years, especially when you had members of our Confederation Congress saying that they wanted it to continue forever, shall forever remain unalterable, unless changed by common consent.
But we're not getting freedoms to decline and refuse without consequences. And that is a violation of our freedoms.
And that's why, unfortunately, we do have to lawyer up and enforce this through the courts. And that's why I'm excited that now that the Ohio Supreme Court has said that they will revisit past precedent, so we have a chance of enforcing our rights under this provision of our state constitution. Yeah.
I think it was 1986 when the tort law reform came into effect.
We've had various tort
This was
reforms.
for like, you know, medical liability. Would that supersede something like this?
So there have been cases where those various tort reforms have been challenged under this provision and failed. But, again, the key is in those cases, the Ohio Supreme Court was reviewing this provision in light of the federal Constitution. And now that they're opening the box, it's a good opportunity to revisit that and say, hey, Ohio Supreme Court, if you look at the history of this provision, it means something different than what you said it meant back in the late 80s or the 90s or the early 2000s when various components of tort reform were challenged under this provision. And we should look at it again.
Can we get a copy of what you showed?
Sure. Yeah, you can send it out.
So don't you think there should be a billboard, call Matt?
Yeah,
You know, Mesney, call Matt.
For free.
Of course.
Should we have him back again? Absolutely.
yeah.
We need to learn more. We need to learn more.
I just was watching Senator Johnson do at one of his interviews, a meeting with a infectious doctor who, from Harvard, is an expert, couldn't answer any of his questions about the mRNA. It is just sickening, you know? Anyway, so thank you.
Thank you, Matt.
And thank you for letting me